The next session is called the Borders of Civility. Civility asks us to respect the international laws of human rights and promote them in practice. But what can we do to make this happen in a society with such diverse and conflicting views? This session will raise questions such as how should we be dealing with issues in Australia that ignite discontent and negativity, and how does this difference enhance and strengthen society in regards to belonging and engagement? And I'm very pleased to introduce the chair of this session, Andrew Tink, author, historian and former New South Wales politician. Sorry about the former, Andrew. I do see your point actually, Donald. Until March 2006, Andrew was Shadow Attorney General and Shadow Leader of the House of the New South Wales Parliament. Since stepping back from active politics, he's concentrated on two of his great passions, writing and history. His first book, William Charles Wentworth, Australia's Greatest Native Son, was published in 2009. And this first comprehensive biography of Wentworth won Andrew the NIB Cal Waverley Award for Literature. His second book, Lord Sydney, The Life and Times of Tommy Townsend, was released in December 2011 and is now in its fourth printing. And in February 2013, he was awarded an honorary doctorate of letters by Macquarie University. His third book, which is a fascinating book, Air Disaster Canberra, The Plane Crash That Destroyed a Government, was released in April 2013. So, Andrew, welcome, and over to you to introduce your panellists.
Thanks very much, John. Well, look, if I can ask the other panellists, please, to come and join us. Andrew, Gillian and Tom, don't be shy, please. I'd firstly like to acknowledge the traditional owners of the land, the Malawau people, and their elders past and present. I also need to explain that I've had radiation for throat cancer, and so I have to drink out of this bottle. It just helps to keep me lubricated. Other than that, there's nothing wrong with me, but I do promise you it contains water, not alcohol, okay? So I'll be hopefully right for the rest of the session. Borders of Civility. When I look at my own very limited life experience and contemplate that phrase, I guess I look firstly at the New South Wales Parliament, which, as you may or may not be aware, is known as the Bear Pit. Well, when I see some of the goings on in the Commonwealth Parliament, I wonder if the New South Wales Parliament is actually losing that mantle. But when I was Shadow Leader of the House, which is to say in charge of opposition business and opposition tactics, and I was in the chamber in question time, if I'd been asked what are the borders of civility, if I was honest, I probably would have said the standing and sessional orders, so far as I can stretch them without getting thrown out of the chamber by the Speaker. And for a long time, that's what governed the way that I operated. I always thought in the context of very robust parliamentary debate, keeping the government to account. Now, occasionally it went a little bit beyond that, but generally speaking, I don't think there's anything wrong with robust debate, providing it's ultimately respectful to other people. It does cross the line occasionally, but I don't think we want to confuse tough questioning and assertive parliamentary democracy, if I can put it that way, with tender feelings. On the other hand, there is a borderline, and I suppose we all perceive it in our different ways, beyond which we shouldn't trespass. And I think that most people in the New South Wales Parliament that I know did not cross that border. But I've moved on from there. My illness took me out of Parliament. I wondered if some of my more robust performances contributed to that after what Andrew Lee said this morning, where he mentioned tension in parliamentary aggressiveness and that somehow that was linked to health. My doctor's since warned me about that and said, never you dare go back into Parliament or attempt to do so, or you'll be for the high jump, health-wise. So I'll never know, but you move on. And I have moved on. And my interest these days, writing and history. And so I now look at this topic, Borders of Civility, in a more historical context. And I look at it in particular in relation to what I think is one of the most important revolutions that we are currently in the middle of, that has taken place in the last 500 years. And if we go back 500 years, what was going on? What was going on in about 1485 or thereabouts was the invention of the printing press, which over the next 50 years overturned society completely and led to, in my opinion, the modern Western world. It was that fundamental. And it took about 50 years for people to understand what was going on and to understand the fundamental importance and the power the printing press progressively gave to the expansion and freedom of expression of thought. And I think we're now in an equally important revolution. If you assume that the internet, from the point of view of the general public, has only been accessible for about 20 years, even though within universities it's been accessible for longer, we're 20 years into a 50-year revolution if you think that there's any relevance at all to what happened in the late 15th and early 16th century with printing. It is an incredibly exciting time. It's a time that I don't understand as well as I should. It's a time when the students from Canberra Grammar up the back there can probably tell us far more about what's going on than any of us understand or realise ourselves. But one thing I do think I know is that it is stretching the borders of civility like nothing I've ever seen in my entire life. Because like the invention of the printing press, and the reason why I think the internet is so revolutionary is that it's turned everybody with access to the internet into a broadcaster. Everybody is now a broadcaster. And what I think is going on with the enormous amount of chaff that is out there, people are shouting louder and louder to be heard. And that's not only individuals, it's people in the media, it's journalists who are fighting for their very lives now. Everybody is out there demanding and scratching to be heard. And again, the Canberra Grammar students may have a view on this, but it seems to me that amongst many young people, a lot of social activity has migrated to the net. And the pressures that used to be there in more traditional ways of, as we all do really. I don't think it ever stops with life. Look at me. Everybody wants the attention, is now migrating onto the net too. And so this social media has some extraordinarily feral aspects to it, which I actually think is changing the way we converse. In other words, to get noticed, you have to shout. There is sometimes a premium on being uncivil, if you like, in the context of what we're talking about this afternoon, to get noticed, to get traction. And I think it's leading us in some interesting, revolutionary and possibly dangerous areas. Now, I was coming down on the plane this morning and looking through a magazine in the seat back in front of me, and came across what I hope is an interesting example of what I'm trying to talk about. This, interestingly, is in a Chinese context. International Consumer Rights Day back in 2011 was a big day for one disgruntled Chinese Lamborghini customer. So appalled was he by the poor service he'd received since buying the $1 million car, he chose to take it back that day. But simply returning the car to the dealership wasn't enough. He hired a team of 9 sledgehammer-wielding men to destroy it on the steps of the dealership and posted the evidence on YouTube. It's a way in which the conversation's changed, where somebody will smash up a $1 million car to go viral on YouTube to make an unmistakable point about his outrage at transgression of his consumer rights. That's perhaps an extreme example, but I think it's that shouting the direction in which we're heading. I don't, though, think it's all bad news, and I was fascinated earlier when Rosemary Johnson mentioned Wikipedia and said that civility was one of the 5 pillars of Wikipedia. Now, it's a controversial medium and everybody's got their views on Wikipedia, but it strikes me that Wikipedia is an attempt through self-governance, as I understand it, to mount what's a relatively civil discussion amongst a whole lot of people who come together collaboratively to put material together on the internet for the common good. And generally speaking, while I would never quote it in a book I'm writing, it is nevertheless an attempt at a civil conversation online. And I think an interesting example of one of the more positive things that might be before us and a model for the future. But maybe this is not the right conversation at all. Maybe there's a different conversation. Maybe we should be saying that the borders of civility that we have at the moment are in fact a golden age of self-expression, something unknown before in history, where anybody can broadcast. And maybe as we read about attempts by countries to hack each other, to close down their internet servers, to mine personal data, including governments in the West and the East and all over the rest of the place, maybe looking back on it, by the end of this revolution, we will say, goodness me, this particular age where we were complaining about lack of civility with online communication was in fact a golden age. And as we look on it, say, in 30 years' time, governments have got control of the internet. I've got no idea whether that will happen or not. I've got no idea whether it's any more possible than governments who tried to control the printing presses hundreds of years ago without success. But I think it's one of the interesting issues that face us. So look, there are some issues from my current perspective as somebody who looks at these things from the point of view of history. Luckily, you will now be hearing from some people who are far more distinguished than I am on this subject. And I'd first of all like to ask Ros Croucher to come to the lectern. Ros is currently President of the Australian Law Reform Commission, having been previously, amongst other things, Dean of the Macquarie University Law School from 1999 to 2007, and Ros is going to be looking at civility and law reform, how we manage the process of engagement, particularly in relation to issues that polarise people. Thanks, Ros.
Well, it's great to be at this podium. When Stephen Schwartz contacted me a few months ago to be part of this, Steve's a very persuasive guy. He's not the kind of guy you say no to. But not only that, but the subject matter that we were going to look at, I think, provided an extraordinary opportunity to take a bit of time out in our thinking on a topic which is very much one of the moment. So I'm going to talk essentially about two themes. Eventually I will talk about law reform, but it struck me that I had to muse a little bit, mull a bit about what the idea of civility was, very much like Donald was saying to us in his excellent address, that it actually provokes you to think, and to think quite deeply. And the two themes that I thought I would take up are about ways of communication, and also the idea of participation as being key to civil society. That being civil requires being civic, or part of the body politic, in the sense of being a citizen. And the idea of participation is a theme that I think has come up in ways of communication and participation, are themes that have come up in many of the presentations already today, which is the importance of engagement, and the flip side of that, the dangers of disengagement, and the way that that can shatter a sense of what a civil society is. Well, to expound upon the borders of civility, which is what we're all doing in our session now, required, I think, an initial reflection upon exactly what civility is. And when I started to peel the layers off this particular conceptual onion, I started a quick search on the broad areas of discourse in which the idea of civility is a recurring theme. Now, unlike Donald MacDonald, I didn't use the Macquarie Dictionary, but I went to one of my favourites on my shelf. My picture shows my bookshelf. I'm a bit of a book addict. And it's very difficult when we downsize offices. I have to colonise all of the cupboards in everyone else's offices to put my books in. Anyway, one of them, and in fact it's one of the ones sitting behind that little happy snap, is my etymological dictionary, which I find a wonderful resource. And civility, etymologically, has links to civilitas, the Latin, about civil government. Of course, it also means other things, but civil with respect to citizens means befitting a citizen. But it slides easily into words and concepts such as being civilised, being polite, even being courteous, words that smack of other etymological roots, courteous of the court, gentility of the gentry, but civility of the citizen. I think, interestingly, the motto of Minnesota, which is something I came across in my random kind of searching around this topic, it reflects civility and its opposite. Civilitas successit barbarum. Civilization succeeds barbarism. Last Sunday, on one of those morning TV shows that I tend to watch over my cornflakes, Gillian was speaking on the topic, has society lost its civility? A number of incidents were mentioned in the introduction, and a number of those are ones that we've already heard about today. Racial slurs on Adam Goodes, a disgruntled fan spitting on Canterbury Bulldogs player Ben Barber, Menugate, the journalist questions of the Prime Minister. During the first of the State of Origin games, Blues skipper Paul Gallen was swinging at Maroons' Nate Miles, what in another era Rex Mossop would have called a bit of biffo. And the revelations, of course, about the sexist conduct in the army. But others examples could be added and immediately leap to mind, or certainly to my mind, an accused refusing to stand in court for a magistrate, a parliamentarian being called a fat man, another mocked for wearing the uniform of a lifesaver, Speedos. We could go on. Driving home one night, again while I was musing on this challenging subject, I heard two journalists commenting about recent events, and they referred in contrast to recent events, to the speeches that were given by John Howard and Kevin Rudd when Howard was defeated. This was described by the journalists on the radio as a masterpiece of civilised discourse, a salute from the victor to the vanquished, and vice versa. The idea of civility and its converse are clearly topics of the moment. There are layers in civility which are distinctly political, befitting a citizen. There are also layers in civility that are about modes of behaviour and conduct that shade into words and concepts of etiquette, protocols of behaviour, decorum, and so on. When I was randomly pulling off things off my bookshelf, I didn't pull off Paul Keating's Book of Insults that Andrew Lee referred to this morning, but rather the Who's Who Guide to Protocol, helpfully compiled in 2001. It helps you learn from example with diagrams, flowcharts, checklists, anecdotes and tips to make you feel more comfortable and confident about protocol. Things like remembering the precedence of flags, the hierarchy of British imperial honours, CMG, call me God, KCMG, kindly call me God, and GCMG, God calls me God, to the appropriate etiquette for visits by the royal family and seating for vice-regal occasions. All such matters are part of the broad umbrella of civilised conduct. I should add our own, our AC, which is our highest honour now, and I thought after hearing Donald speak, that's amazingly cool. Well, the mores and rules of social interaction in a formal sense tap into a deep sense of how civilised people behave. After barbarism comes civilisation, and the many nuances of civilised behaviour. For lawyers, the literature on codes of conduct, codes of ethics, reflect very much the idea that Donald was raising with us, that civilisation, to be civil, relies on a profound sense of ethics, and the legal profession and our codes of ethics are full of the language of civility. The legal profession cares about civility, is how one American professor described it in an article entitled, Does Civility Matter? A speech delivered at the opening assembly of the annual meeting of the American Bar Association in 2011 was entitled Fostering Civility in Public Discourse. Many of these things, the language of legal ethics and professional practice is redolent with ideas of civility. Chief Justice Warren Burger of the US spoke of civility within the legal profession as really the very glue that keeps organised society from flying into pieces. The former Chief Justice of New South Wales, James Spiegelman, AC, used many occasions to speak publicly about civility and the legal profession, and more generally. He talked about the extraordinary capacity in Australian society for the integration of disparate groups into a cohesive, tolerant and inclusive society. And with respect to the legal profession, he said it means much more than matters of etiquette and manners. The core element of civility is the manifestation of respect for other persons. And in the context of lawyers and lawyering, Spiegelman points to the tradition of civility as being recognised as a fundamental ethical obligation of a professional person. And he contrasted the decline in civility apparent elsewhere in society, such as the Cronulla riots, and exhorted his audience, who were of course lawyers, to continue the tradition of civility of the legal profession as well recognised rules of proper conduct. Turning from that focus to more general observations, I want to focus on the specific topic of our forum. What then are the borders on civility? Well, let's reframe that question in terms of what happens when one is uncivil. The flip side of civility surely lies in consequences. And here one can imagine a sliding scale depending on how hard-edged that border is defined within the structures of a civilised democratic state. If you are rude, offend someone, or breach the nuanced expectations of etiquette or social graces, you might not get asked again. So uncivil may have been your transgression that you were struck off all the guest lists of the friends of the friend you offended. You are banned from a club, a sporting team, suspended for a match, a season, for life. You may be excommunicated or expelled from a religious group. You may get struck off the roll of practitioners. You may go to jail. The hardest borders on civility lie in law. But one should also pose questions in testing the borders that we impose, whether through social convention or through law, because by testing the borders, we affirm the commitment that civilisation follows barbarism. I note here the question that we should ask: do we go too far in condemning incivility? MacDonald talked about a need for robustness and retaining a sense of humour. I note also the discomfort that was felt in the consolidation exercise of the anti-discrimination legislation, which verged into areas of being offensive. Do we become too precious, too prudish, and therefore intolerant? Because if intolerance is not the antithesis of civility, it is certainly a word that does not sit well within the concept of civility in a democratic state. Now, to make the segue into the ALRC, and I'll only spend a couple of minutes on that, Chair, I found some very interesting work done by two of the Boyer lecturers. Martin Krieger was one and Eva Cox was the other. And Eva, in her Boyer lectures in 1995, examined a truly civil society, and she drew upon the work of German Jewish philosopher Hannah Arendt, who had fled Hitler. And Arendt had spoken about the importance of what she called vita activa, the public life, and that to be fully human, you had to participate in public life. To counter incivility requires participation. Civil societies are civic societies, and we as citizens must take some responsibility for changing what we do not like, according to Cox. Well, at the ALRC, we do two things, I think, that reflect these themes. One is the way that we conduct a civilised communication, and the other is the way that we facilitate the participation and engagement in a particular kind of civic process of law reform, which ultimately leads to some change in certain structures in society. And part of our civilised communication and our respect is an acknowledgement to traditional custodians of land. And I'd like at this point to make my acknowledgement on behalf of the Law Reform Commission to the Ngunnawal and Ngambri people of this place, and to acknowledge any Indigenous guests in the audience today. Our communication strategy at the ALRC is based on a consultation plan. We have a range of ways of involving the public in our very, very many processes. And I would describe that the commitment to consultation as a demonstration of civility in the context of law reform. And perhaps I can conclude with a few brief observations. That respect for the integrity of another, whether an individual, an organisation or a nation, and respect for process, the commitment to and practice of listening, reflective analysis and communication through fair and balanced reporting are the true hallmarks of civility, particularly in the context of law reform. It is a different space from the greeting and place settings for the royal family, but it does express a kindred sentiment. And it is a process that facilitates participation in civil society through a distinct lens, and in that way manifests a particular aspect of the vita activa to which Eva Cox drew our attention. A civil society is a civic society, and to counter incivility requires participation. And this, I think, is where the Australian Law Reform Commission creates a very specific space in a civil society. Thank you.
Thanks very much, Ros. Our next presenter is Emeritus Professor Gillian Triggs, President of the Australian Human Rights Commission. And among other things, Gillian has previously been Charles Professor of International Law at the University of Sydney. Gillian will be talking to us about international human rights law and how we can promote these standards in the community generally, especially in relation to cultural competence and education. Thanks, Gillian.
Thank you, Andrew, and thank you, Ros, for setting the scene so beautifully for what I would like to talk about, which is really the point that she made, the boundaries and the borders that law can provide in dealing with this curious question of civility. I've very much enjoyed the presentations that I've been able to listen to today, particularly in relation, obviously, to democracy, to the role of the arts, and to hear a very particular perspective from Mr. MacDonald in relation to censorship. And one of the areas, of course, that I will be mostly concerned with is the extent to which notions of legislating for civility can breach or run counter to our rights to freedom of speech. I think it's wonderful that the Canberra grammar boys are here, and I very much like their senior teachers' questions about notions of practicality, and I do want to be fairly practical. But I began, like so many others have today, by going to the shelves. I'm a public international lawyer. I deal with law, and as President of the Human Rights Commission, my mandate is to deal with international human rights law. What is the law, I ask, when I look at the rights of asylum seekers? What is the law when a 13-year-old girl uses a racial term to a footballer? So I'm a little out of my crease when I start to ask or look at the very interesting questions of what is civility in law. So I went to my book of quotable quotations. You're all a little more scholarly than I was. But I found that Sheridan, speaking of somebody he knew, he was too civil by half. Samuel Johnson, speaking of somebody, said he was so generally civil that nobody thanked him for it. And then we have the one that I preferred, also from Johnston, civility costs nothing and buys everything. And I'd have to say that's very much my experience of life. And to the extent that I'm an international lawyer and have had something to do with diplomacy, I should be very interested in this afternoon's next session on the role of diplomacy and civility, because I do wonder about the role of civility in diplomacy. I've just come back from Geneva from 5 days of grinding civility and politeness that I think achieved very little. But to come back to what can only politely be described as robust discussion in our political environment, I am rather bemused as to exactly where we stand in relation to this. But I do have some statistics. At the Australian Human Rights Commission, we can't operate on the basis of anecdote. We have to deal with law and we have to deal with facts. And as many of you will know, in any one year, we deal with something like 18,000 inquiries or formal complaints. Complaints must come through the Commission before they, in rare cases, go to the courts. And it's unfortunate that I'm able to report that we've had a 39% increase in complaints about racial vilification over the last 2 or 3 years. The numbers are going up exponentially. Now, the sociologists amongst the group may very well say there are reasons for that. One is that you can whip out your iPhone on the train and take a picture of the abuse that's taking place of a Sudanese young man, or you can record or send tweets while you are being abused yourself on a bus in Sydney. I don't know the answer to this question. All I know is that the level of racial vilification is high and we're increasingly aware of it. Well, my key question that I wanted to deal with today is, to what extent can one really legislate for this notion of civility as being civil, as Ros has described it, playing a civic role in the body politic? And it's extremely interesting if we look, for example, at the views of our High Court judges when faced with legislation that in various ways across our society and to a very significant degree actually legislate against certain forms of speech. And there's a very interesting split right down the middle of our High Court. Some judges, led by Chief Justice Gillian and Dyson Hayden, both of whom have relatively recently retired from the court, and their views when looking at legislation which has proscribed an act or language that has been offensive, have themselves said or emphasised that civilised political discussion, where freedom of political communication serves to protect the quality of public discussion, can be controlled through, and should be controlled through legislation, that only through civilised political discourse can we have a rich and balanced debate. But on the other side, we have judges such as Justice McHugh and Justice Kirby, also retired recently, or relatively, where they say, not at all. Robust, even aggressive political debate in which hurt feelings and intimidations are costs to be borne but not avoided should be accepted within our Australian society. On balance, it seems that the High Court has actually rejected the idea that civility is valued in political communication. And I'll give you a recent example. In the last few weeks, the High Court of Australia gave its decision in a case Monus and Drondis. Now, you won't probably know those names, but you might know the facts. And this was a case in which 2 individuals in Australia wrote letters to the parents and to the relatives of soldiers killed on active service in Afghanistan. And they did so in brutal terms, saying that these young men had acted in ways that were traitorous, that they had acted contrary to the to religious interests of Muhammad and of Muslims, and that their acts were to be condemned. These 2 letter writers were charged under the criminal code and this is often what happens in the law. You have a very big political and legal issue, but it's dealt with on apparently a trivial basis. It's about a bit like prosecuting Al Capone for tax avoidance. Here these people were charged with misuse of the postal services and that they had used the postal services to offend. Now, the question for the court at the High Court level was whether or not these letters offended or whether the legislation was an impermissible burden on our implied right in the Constitution to freedom of political communication. I labour that word implied because, as many of you will know, we do not have a right to freedom of expression in our Australian Constitution. We must rely on the courts and on the common law. The question for the court then was this an impermissible burden on this right? And would a reasonable person be offended in all the circumstances? The test being is, what is a legitimate aim of the legislation? And was the legislation a necessary and proportionate means of achieving that outcome? Now, 3 of the judges said that freedom of speech and the right to political communication meant that these letter writers could say what they did to the parents of these servicemen who died in Afghanistan. 3 other judges, interestingly, all the women on the court, said, no, enough. This is offensive language. It was intended to be offensive. It did offend. And the Postal Service Act, or provisions within the Criminal Code, was an entirely appropriate basis for prosecution on the grounds that there are limits to freedom of speech. There are limits to the right of freedom of political communication. That meant that we had a 3-3 decision in the High Court, and as maybe our students from Canberra school know, that means that the decision of the lower court stands, and that meant that the conviction of the 2 accused remained in place. But you will also realise that that means that the matter really wasn't adequately solved, and we will doubtless have more cases coming before the court in the future. So it fascinates me when I started to look at this question that we really have a very ambivalent attitude to the way in which we legislate for those that offend us or hurt us. And that brings me to the Human Rights and Anti-Discrimination Bill that was introduced by this government in the late part of last year. This is a bill which was said by government to be a consolidation, but in reality it was a great deal more than a consolidation of human rights law. Sex discrimination, race discrimination and disability were the primary areas. What it did was to take the existing law, consolidate it in an entirely sensible way, a coherent way, but create new law. But what it did was to take Section 18C of the Race Discrimination Act and expand that language to new protected attributes. Now, what I'm saying is, and those of you, some of you may recall, the Race Discrimination Act in Section 18C says that you shall not offend, insult, humiliate, intimidate a person in a public place on the grounds of race. There's nothing new about that. This legislation has been around since 1996, and it is very, very rarely used. Disputes in relation to it must come to the Human Rights Commission first. If we can't settle it, in rare cases, it will go to the federal court. What are examples of that? Well, one you may very well know, the case of Mr. Bolt, where he acted in a way which was seen as deeply offensive to our First Nations peoples, our Indigenous peoples, and the prosecution was upheld on the ground that his language was both offensive, insulting, intimidating and humiliating, and he satisfied none of the defences that members of the journalistic community can usually rely on: accurate research and good faith and commentary in the public arena. On none of those bases could he claim a defence, and he was ultimately prosecuted, or the offence was made out under the Race Discrimination Act. But that case formed a very interesting foundation for what was to become the public discussion on the way the bill that was introduced by the government used exactly the same words, offending and insulting, but brought them across to new attributes, being social origin, religion, industrial history, medical history, and so on. These were all new ideas, and for the first time, we found the Australian public debating law that had been in evidence for a very long time, but had never really been discussed. It's an interesting footnote to this that the Chief Justice Spiegelman that Rosalind referred to, I had invited to launch our Human Rights Awards last year in December, and he used that award as the opportunity to make that speech in which he effectively ridiculed the use of the words offending and insulting. And he did so. He's a marvellous orator, a great scholar, a great Chief Justice of New South Wales, and he was very effective in using humour and ridicule to say Australians can cope with the cut and thrust of being offended and insulted. Now, the end result of this was a very significant and public debate on the question of the extent to which Australians should be able to be thick-skinned enough to deal with insults and offence. And the government, as you know, Attorney General withdrew that bill just a short time ago, and I suggest it's highly unlikely to be reintroduced. Now, that is a legal example of how governments are attempting to use laws to create borders for levels of civility, and it has been extremely controversial, and the High Court itself is extremely divided in how this matter should be dealt with. Now, I'd like to come very briefly to tell you a little bit about what I think, or one explanation for what I see as being a decline in civility in the public arena in which we all operate. And it's a point that perhaps is not readily understood in Australia, but the reality is that we've been extremely good international citizens. We have ratified and were engaged in negotiating most of the major human rights treaties in international law. From the early days of Doc Evatt as President of the General Assembly and the Universal Declaration on Human Rights, unanimously passed under his presidency, right through a series of international treaties, right up to the creation of the Rome Statute, an international criminal court in the last 8 or 9 years. But the reality is that while we have signed and ratified these treaties, we have not given them domestic effect in our local law. So that although we have race, sex and disability, none of the others are directly part of Australian law. So that as President of the Commission, I can talk about a subject that a couple of you have raised already, the rights of refugees or asylum seekers, or I can talk about freedom of speech. But an answer that certainly a judge will give me, but certainly also at the political level is given to me, is, that sounds terrific, Gillian, but it's not part of Australian law. We do not have the International Covenant on Civil and Political Rights as part of our domestic law. You cannot go to a court and argue for those rights to be enforced. So my suggestion, and I'd be grateful if we could think about it a little more as a nation, is if we had the borders of created through these treaties in our domestic law, we might be more alert to what our rights are, and rights ultimately come down to respect and ultimately to civility. So I think it's a great hole in our Australian legal system that almost every other comparable civil or common law jurisdiction has a Bill of Rights, but we do not. Almost all countries have constitutional protections for core civil rights, but we do not. We have piecemeal bits of legislation. We have some judges who've been prepared to look at these standards, and we have some pieces of legislation that include other rights. It's very interesting, for example, in the public debate that we've been hearing in the last few days, that we should withdraw from the Refugees Convention, and that would solve all our problems with people coming to Australia, is an illustration of sheer lack of knowledge, because the Refugees Convention does not deal with the rights of asylum seekers. That right rests in the Declaration of Human Rights, a universal declaration that Doc Evatt himself was so instrumental in bringing into effect. Withdrawing from the Refugee Convention will be a significant defect, a significant message to the international community that we are not engaging in these aspects of human rights law, and we really should think very carefully before we resile from the parameters of law, which I think provide effective parameters for civility. Thank you very much.
Thanks very much, Gillian. Well, we have two very interesting presentations to compare in a way. I made a note of Ros saying that the hardest borders in civility lie in the law, and I think that's undoubtedly true. That's undebatable. But then Gillian raises the point that the lawyers in the highest court in the land can't agree on what the law is, which brings us back to the politicians and appointments to the High Court. which brings us to the next point, which is that politicians appoint people to the High Court and they think they know what they're going to do. And history tells us time and time again that they've got no idea what they're going to do, because people who are appointed to the court do different things to what they may be thought to do by the people who appoint them. So it's a very, very movable feast in terms of legislation, the role of the Parliament, the role of the courts, and where those hard, final legal boundaries lie. It's now my great pleasure to ask Tom Calma, Dr. Tom Calma, to address you. Tom is the National Coordinator of Tackling Indigenous Smoking, and among other things, he's previously been the Race Discrimination Commissioner from 2004 to 2009. And I think most significantly of all in some ways, Tom, you're currently the ACT Australian of the Year yeah, absolutely. And I think this is highly relevant, and I'm summarising here a little bit. The citation's a little longer than this. For your work as an inspirational advocate for human rights and social justice. And Tom's going to talk to us about dealing with incivility through empowerment. Thanks.
Yeah, I'm glad you said that, Andrew, because I guess everybody's saying, what's this got to do with controlling tobacco use? And nothing really. But that's one of my day jobs. But I'm also the co-chair of Reconciliation Australia, which I think is much more relevant in our discussion here today. Can I begin by acknowledging that we're in the land of the Ngunnawal peoples and the Ngambri peoples, and pay respect to their elders past and present, but also to recognise their youth and all youth of Australia, because youth are going to be our future leaders. They're going to be the custodians of our stories, our language, our cultures. And we as more senior youth need to make sure that we create the opportunities and provide that level of support and nurture our youth into these leadership positions, and to also create the environment where you have good role models and people who you can look up to and respect, and also to make sure that we as more senior people who can get access to some of the multimedia ensure that we do lead by good example. Thank you, Donald, for mentioning the Golden Rule, because yesterday I participated in the launch of the Golden Rule in the New South Wales Parliament, and I gave the keynote address to that. And what's interesting about the Golden Rule, as Donald said, one should treat others as one would like to be treated oneself. And what's interesting is that all the major religions and belief systems all have that very same or very similar creed, including Aboriginal and Torres Strait Islander people. And so this was a multi-faith dialogue that we participated in yesterday. And the good thing about it is that a poster has been created, and that will hang in the New South Wales Parliament, a big version of it for all to see. But it'll also go out to schools to help educate and to inform people, because for us to have a civil and have civility in our society, we need to be informed and educated. And that's why this summit about expanding the boundaries, being open to learn, to teach, to hear and to change, are really key important issues that we should all look at. So what I've decided to do, knowing that there's a lot of experts around here, is really to not look at civility itself, but to look at incivility, and to recognise that as a key issue, that why we need to look at our behaviours. Now, I had 5 minutes, so if I seemed rushed, it's because I am. Incivility is a general term for social behaviour lacking in civility or good manners, on a scale of rudeness or lack of respect for elders to vandalism and hooliganism through public drunkenness and threatening behaviour. That's in general terms, the opposite to what civility is about. But I wanted to focus a little bit on workplace incivility, because I think too often we don't think about it. We think about it in the public arena and what's out there and what we see on the television and behaviour on the footy field and so forth, but not recognise that it does happen in the workplace, and it also happens in the classroom. A 2011 report in US Today defined workplace incivility as a form of organisational deviance characterised by low-intensity behaviour that violates respectful workplace norms, appearing vague as to the intent of harm. Uncivil behaviours are characteristically rude and discourteous, displaying a lack of regard for others. Incivility is distinct from violence. And examples of workplace incivility include insulting comments, spreading false rumours, social isolation, and so forth. And I think they're really important to think about for all of us. But I wanted to look specifically at an issue that relates to Aboriginal and Torres Strait Islander people that's not necessarily in the workplace, but a number of those traits that I mentioned are very common. And my successor as the Social Justice Commissioner, Mick Gooder, has championed this effort, and I draw from some of the works that he did in his first social justice report in 2010, and that was to talk about lateral violence in Aboriginal and Torres Strait Islander communities. Lateral violence is a significant problem facing Aboriginal and Torres Strait Islander communities. Lateral violence, also known as horizontal violence and interracial conflict, is the product of a complex mix of historical, cultural and social dynamics that result in a spectrum of behaviours that include gossiping, jealousy, bullying, shaming, social exclusion, family feuding, organisational conflict and violence. And one of the real champions who's doing a lot of work in this area is a guy called Richard Franklin, an Aboriginal guy in Victoria. And he describes lateral violence to include the organised, harmful behaviour that we do to each other collectively as part of an oppressed group within our families, within our organisations and within our community. When we are consistently oppressed, we live with great fear and great anger, and we often turn on those who are closest to us. And we see that manifested quite often in Aboriginal communities, and there's a whole range of reasons, and we have to go back to really looking at the core, and this is what we're doing with Aboriginal communities, is going back to the core and looking at why people's behaviour isn't always civil, and it falls in the realm of incivility. And it goes back for us to the time of colonisation and the control of Aboriginal and Torres Strait Islander people. The experience that we've had with powerlessness, the diminution of traditional Aboriginal behaviours, structures, roles, etc., and also the environment that we currently live in, and a conflict for some Aboriginal people with identity, and that identity is not just because they don't identify as an Aboriginal people, but it's how others might perceive that identity. And Gillian mentioned the case of Andrew Bolt and how he may or may not have interpreted who an Aboriginal person is. Now, whilst lateral violence has its roots in history, there's also the other reasons that I mentioned. And it's basically in all societies, and whilst I talk about Aboriginal and Torres Strait Islander people, I'm sure that we can relate to this in our own families, and particularly around Christmas dinner and the build-up to it. It tends to go where we do really take jibes at each other and look at that behaviour. But it's about disadvantage, it's about disempowerment, and it's about the lack of control. And these are the issues that contribute to incivility. It's about the negative stereotypes which create the low esteem, and that, as I said earlier, turns to powerlessness. It's about how we can ensure that we live and work in an environment where people are civil to each other and not in an environment where there is incivility. And it's about how do we empower people to understand these issues. And a lot of it's about empowerment, and empowerment comes through education and also through a respect of somebody else's position, and that respect is through acknowledgement. I think some of the clear examples that I'm sure were mentioned earlier, were about cyberbullying, about young people and bullying in schools, in classrooms, organisational conflict, workplace bullying, social and emotional well-being and involvement in the criminal justice system, which in fact is counter. We think that there's a number of key issues that need to be looked at, and they include self-determination, participating in decision-making processes, making sure that others, from politicians to bureaucrats to the media, don't identify who they think are Aboriginal leaders and Torres Strait Islander leaders or any other leaders, and therefore alienate the rest of the population because they go to certain people to get favoured information. These are key issues, and then they're issues that we're addressing at an international level. But the issues of non-discrimination, which Gillian mentioned, and equality, respect for and protection of culture, and also about cultural competence and making sure that workers, people who work with Aboriginal and Torres Strait Islander people or any minority groups, get trained up about cultural difference and understand it so that they don't offend, so that they are treating people with respect and in a civil way. The other one I wanted to talk about was just very quickly, and whilst it relates often to men and boys, it also is something that we can look at across the nation. And you may have heard of the White Ribbon Campaign, and it's about men who stand up against violence against women. And we know that incivility and violence, there is a difference, but we also know that when we talk about violence against women, we're also not just talking about physical violence. It's about any act of gender-based violence that results in or is likely to result in physical, sexual or psychological harm or suffering to women, including threats of such acts, coercion and arbitrary deprivation of liberties, whether incurred in public or in private life. So it's about controlling people's lives, women's lives. Just a couple of those key issues are things like elder abuse, put-downs, spiritual abuse, verbal abuse, emotional abuse, forced isolation from financial situations and isolation from family and friends. These are the non-tangibles that happen out there that are perpetrators that are really leading into uncivil behaviour. And I think it's incumbent on all of us, and particularly on men, to understand these issues because they are incivility in practice, and to do what we do, and I'm an ambassador of White Ribbon, is to swear an oath. And it is, I swear never to commit, excuse or remain silent about violence against women. That is my oath, and I hope you guys think about that too. Thank you.
Many thanks, Tom. I mean, personally, I found that a very moving address. And thank you very much for it. I was also intrigued that you were up in the New South Wales Parliament yesterday concerning the Golden Rule. There are a few of my former colleagues up there who need constant reminding of it, I'm afraid to say. Victor Dominello accepted. Yes, he's a good man, Victor. It's now my great pleasure to ask Andrew Jaspan to come and address you. Andrew is currently the editor of The Conversation, an independent not-for-profit website of analysis, commentary and news for the university and research sector. Between 2004 and 2008, Andrew was editor-in-chief of Melbourne's Age and the Sunday Age, and prior to that he edited The Observer in London, The Scotsman, Scotland on Sunday and the Sunday Herald in the UK. Andrew is going to say something about how uncivil e-society has become and about the lack of civility in online debate and communications, especially by bloggers, and how that's coarsened public debate overall. Andrew.
Thank you very much. I just wanted to start off by saying that I also, Gillian, like yourself, got a very persuasive email from Professor Stephen Schwartz. Unfortunately, the relationship between him and I is slightly different. He's one of our esteemed authors on the conversation, and I have to treat all authors with a great deal of respect. So when the email came through, I had only one answer, which is to say, of course, Stephen, you contribute to the conversation, I'll contribute to CHASS. And by the way, you need to update your CV. You say that you contribute articles to newspapers and magazines. Could you insert the word online publications as well, please? You need to move on, Stephen. Keep up. Look, I'm going to divide my talk, which I'm going to try and keep to about 10 minutes, into two 5-minute sections. The second bit talks about the problems we have with online media. But I thought it would be rather rude of me not to tell you a little bit about what the conversation is actually about. And I'm going to show you some slides, which are my TED Talk slides, and TED Talks are 20 minutes. I'm going to show them to you in 5 minutes or less. So I'm actually not going to talk to a lot of these because they're kind of just like a word puzzle, and hopefully at the end of it all, you get a feeling for what the conversation's about. So the first thing is, I used to work in newspapers and online, and I wanted to discover where we're going to find trusted information in the future as the business model of the media was collapsing. And what I mean by collapsing is due to falling profits, which means falling advertising revenues. Every one of the media companies, pretty well in the world, with the exception of some of the developing countries, had to reduce costs, which meant, largely speaking, taking out staff and taking out journalists. So this is, if you like, a new approach towards journalism, and I'm going to quickly flick through it. Hopefully this is working. So that's the quest, and I'm going to go through this pretty quickly. Not sure if I'm pressing the right place. Sorry? So that's what I set out to do. I'm going to try and do this quickly if the slides can keep up with me. So my argument is the media has largely lost its moral compass and broken its trust with its readers or with society. So the idea was to explore an alternative, a new model for journalism. Come on. So the model here is all our authors, including, as I mentioned to you earlier, Professor Stephen Schwartz, are academics, but all the authors work in collaboration with professional journalists. So we have 16 professional journalists. Oh, thank you. Oh, thank you. We have 16 professional editors who work with academics, and we have 6,000 academics in our virtual newsroom, as we call it, and we work together to produce all the content for the conversation. The other thing is, rather than just explaining complexity, we want to go one step further, which a lot of the media are not good at, which is to actually provide our readers with solutions. So don't just bring your readers the problems, also give them some possible solutions. We don't give the solution, we give a range of solutions. So fundamentally, what this site is about is how can we have better informed civic conversations online. And hopefully, the site has a purpose in society. But to do so, we think the key thing we have to do, you can't just assert these things, you have to work hard. You have to demonstrate that you're actually going to do things in a different way. What we wanted to do was to rebuild that trust through a series of protocols. First of all, the only people who can write for us have to demonstrate that they actually really have deep knowledge of their subject matter, sometimes called subject matter expertise. A lot of journalism is about people who actually know very little about something, who have to mug up on it quickly and then write it by a certain deadline. That is not the model here. Only those who really know deeply about this subject matter can write. And by the way, I forgot to mention, Stephen did write a piece about this very subject that we're discussing today on The Conversation. If you haven't read it, please do. Second thing is, before you write, you need to disclose your funding. How many times do we read things in the media and you have no idea who the person is? You don't know what expertise they bring to the subject, or whether, as many columnists do, they just think every week, and I know these columnists because I used to work with them, every week they just say, what shall I write about this week? They have no ideas, and usually I, as the editor, would give them an idea, and they say, oh, okay, I'll write about that. They do a day's research, and then they knock out a column. You first of all have deep expertise. Secondly, you need to say who you are. You need to explain who funds your research. You need to explain to the reader if you have any conflicts. In other words, if you're part of an organization which could benefit from the article you've written. Now, there's no problem with a conflict, but just disclose it. And then everybody knows that actually you're being honest with the reader. And we have codes of conduct, very strict codes of conduct that apply to my team, but also to our authors. And a lot of those codes of conduct were built on the codes of conduct that exist within the university and academic sector. And a lot of this is to do with the way you carry out your research, the way you conduct work and collaborate with your peers, and so on and so forth. So we've now built, as I say, Australia's largest virtual newsroom, 6,000 people writing, 16 editors. And by the way, I'm just back from UK. We've just launched in the UK on May the 16th, and we have 12 people now based in London, and we hope also to export this to other parts of the world. So the idea is to unlock the rich expertise which you, by the way, as taxpayers, invest in the university and research sector. I should have mentioned CSR, our own major partner of ours as well. You invest this money, we unlock it, and we share it with the wider public. What we also hope we're doing is introducing new voices into the public arena and new ideas. So it's not the same old faces with the same old views. These are new, fresh voices. And hopefully, we're giving our readers, through all those codes of conduct, an informed and intelligent debate. And best of all, everything you read on the site is free for you to read, free for you to share. Everything's published under something called Creative Commons, so anybody here can republish it. And this is my last slide. That, we think, is the basis of an informed 21st century democracy. So that's my 20-minute talk, hopefully in 5 minutes. Now, if that's the problem, what I wanted to share with you is if that's a solution, what I wanted to share with you is a problem. And this is a problem which is a real one, and I actually am hoping that CHASS might help us with finding a solution to this. We call the site The Conversation, and The Conversation means that we need to hear from those people who are reading, who write back to us. There's a problem, though, in this space. First of all, the moment you open yourself to the public, as the site is the floodgates are open. Anybody can pretty well come in. We've got a whole bunch of codes of conduct around who can write. The first thing we've said is no anonymity on the site. Sounds good. The problem is people write under false names, and despite the fact we keep saying prove who you are, they then come back with another false identity, and so it goes on and on and on. So it's very, very difficult to police this space. The second thing is that this space actually has encouraged outrageous, awful behavior. It's crude, it's rude, it's defamatory, it's brutal, this space. And part of this is because everybody now thinks they're entitled to their opinion. Everybody. Everybody's an expert. Everybody can write, broadcast, do whatever they like. But I tell you what's interesting. This article here, No, You're Not Entitled to Your Opinion, which again you can read on our site, is one of the most read. It's had about 600,000 reads since we published it. So it's essentially saying, look, everybody can have a point of view, but on this subject, you actually don't know what you're talking about. Now, not often do we say that, but it was a very controversial article, and I encourage you to have a look at it. So what we've got now is what I think is a very corrosive debate, which is actually permeating out and coarsening public debate generally. And I've got some comments here by readers who say here, for example, if you can't read it, I feel frustrated by the current tone of our political debate, or lack of. No one seems interested in debating policy anymore, just personalities. It makes me scared for our future and the message we are sending to the next generation. How will we ever progress as a society if we create an environment where people want to disengage from decision-making of our supposed representatives? Now I want to give you a couple of case examples. Michelle Grattan. Michelle and I worked together at the Age. She left the Age and joined the University of Canberra. She's a professor or a fellow at the University of Canberra, and she writes for us as well. Now she's doing a project which the University of Canberra is funding, which is a research into the bellwether seat of Eden Monaro. So she wrote this piece, and then this is the response we got from it. It's what I call the blogger's salute. Fuck off. That's all it comes back, you know. And that goes on, by the way, non-stop in the space that we get, non-stop. And it goes on to say, you know, Michelle, do you ever write about serious policy or just political gossip? So please stop writing about it. Unless the words I'm retiring are in this, I'm not interested. And that's the kind of debate that we're having, and it's a real problem for us. So here we have again the gender war. So what do we get? Michelle writes a piece of analysis about it, and the writer comes back in saying, please send Grattan back to Fairfax where she belongs if she's going to keep writing this drivel, and so on and so forth. Overplayed gender card, the statement is sickening. Michelle Grattan, get out of politics and get some perspective. That's civil debate on a site which is committed to better conversations. Is that the best we can do? And of course, we've got the Pickering Post, you know, and again, I was wondering if I should even give any exposure to this site. It is the pits. So, on our site, we actually have a statement about how we want to have civil debates, and we actually ask people to avoid personal attacks. We actually say this is your space as much as ours, but if you want to come into this space, please conduct yourself in a civil way, which means fundamentally obeying certain very basic rules, which many of us have discussed. I was going to show you some of the definitions of civility. I think virtually all the speakers today have given you a good feel for that space. Now, the problem is that this space is largely unregulated. The people who write in this space, because they hide behind anonymity, get away with it. Secondly, a lot of the statements made are defamatory, but because we don't know who they are, or because many people who write in it actually have made sure they have no assets, some of them have no income, they can get away with it. So if we were to actually go and chase these people up in terms of actually bringing action against them, they would go to court and say we have no funds, we can't defend ourselves, and then it looks like bully boy activities on our part. So it's an unregulated space, and it's pretty ghastly, and we're not quite sure what to do. So I'm leaving this for discussion. I'd like to know what we might do. One example that a lot of sites do is something called pre-moderation publication of comments, which means you have somebody to read them all, and then only those that are seen to be fit for public consumption, as it were, are then published. But that slows down the whole process of a conversation. However, that's a possibility, and it's something that, again, I'd like to think John and Stephen and others at CHASS, it's something that you might like to actually help us with finding a way through this morass. Because if we don't tackle this, and it's not just our site, because our site is actually dedicated to better public conversations. There are many sites worse than ours, and I can tell you, Donald, that even at the ABC, they're grappling with this problem. And the question is, do you just switch off comments? So this is something which is a very serious issue, and it's infecting the larger political body politic. So thank you very much, and I'm sorry to leave you on a bit of a downer note, but that's a problem, and I'd love to hear it discussed. Thank you very much.
In a roundabout way, that seems to be a plea for editing, which sort of takes us a step back. Well, look, out of those four very wide-ranging and interesting presentations, do we have some questions, please?
Hi, my name is Pam Fu. I have a question for Professor Croucher. You've talked about the role that the laws play in setting the parameters for civil society. I was just wondering, what are your views on the role that governments can also play in determining civil society, and in particular looking at the recent situation of the CIA whistleblower that fled to Hong Kong because he thought that his rights were better protected under the laws of Hong Kong freedom of speech. So I'm wondering what your thoughts are about whether or not the intrusions of government into citizens threatens the social contract, and if government can really be trusted to maintain civil society.
Goodness, that's a set of questions. I'll answer a little bit of it because I think they're almost rhetorical questions in many respects. When I was talking about laws being the borders of civility, well, laws come from government, and it's through the process of debate in government that the shape of those laws are ultimately determined. And that process has certain pragmatic ways of filtering and changing the shape, as Andrew would testify robustly, I'm sure. But laws are an expression of government because that is their source. That is the way that they are placed into actionable form. The other element that you raised about whistleblowing, I might just comment on that, partly because in the ALRC's work we've supported that idea for, in our secrecy report, for example, we referred to the whistleblower discussion that was at that stage working its way through the public psyche through the processes of Parliament in one shape or another, and it's just come through. I was reading that Dreyfus has actually got that through, certainly the reps. And I think something like the whistleblower, and I'm uncomfortable with that term, but I think it's one that is pretty familiar to people. It's a way of establishing a process through which appropriate complaints can be channeled. And when anybody looks at the whistleblowing issue, the arguments are always around whether the channel is created in the right way, at the right level. Why can't you go there first? Why can't you do this, that, and the other thing? But it is a process of providing an outlet for complaint. Much of law is about providing a process, whether through the criminal law or through the civil law, a process through which complaints can be made. And that particular legislation was a very important chunk in our action at a public level, protecting particularly public servants who otherwise might be exposed to all kinds of things, particularly under the Crimes Act. Up to 20 years in jail is one of them. So it's an important element of a process through which some of those borders on appropriate conduct in public office can be created. So I might just leave my observation to that.
Would anybody else like to add anything to that? Other questions?
My name is Dorothy Broom, and I want to raise a question particularly for the lawyers on the panel, but not only them perhaps. One of the things that concerns me is the way law is increasingly being made through international trade agreements that are in fact being developed and to a great extent lobbied about in a very undemocratic way, and in which civil society has little or no input or access. And lest you think this is terribly abstract and irrelevant, it potentially goes to the capacity of Australia to impose law that protects the public health and well-being. For example, we are, I believe, being subject to litigation against our plain packaging through plain tobacco packaging through international trade complaint procedures. And there are a myriad other trade agreements that are in the process of being developed behind closed doors in a very secretive way. It seems to me it's a threat to democracy as well as to civil society.
Gillian?
Yes, well, thank you. The terrific question. And it's something that was, one has to be eternally vigilant about. The position in relation to civil society in the WTO, for example, has now become, is much more integrated. NGOs now can attend meetings and so on. They can even produce amicus briefs for the appellate body complaints process. So there have been significant improvements. On the very particular question of health, it is highly probable that although, as you know, complaints have been brought by Honduras and Uruguay to the appellate body complaint process of the WTO, there is a very important article in the old GATT, the new WTO system, Article 20, which specifically allows a state to, in good faith, and not as a disguise on protection of trade, to legislate for health and among other matters, and protection of species and natural resources. So I think that there's a very good chance that the plain packaging legislation could survive that. What is much less likely to survive is the process in bilateral dispute resolution, and that is the bilateral agreement with Hong Kong that has enabled a restructuring of the company, one of the companies, Philips in particular, that's restructured to take advantage of Hong Kong residency, and that allows it to take advantage of a bilateral investment treaty with Australia. Now, that's all very tedious detail, but the point is to underscore your concern, and that is that with bilateral arrangements, you can actually do this outside scrutiny by civil society. However, there is an answer for Australia, at least, and that is that after a great deal of criticism, essentially making your points, Australia brought in, after a report called Trick or Treaty, the obligation that treaties must lie on the House for each House of Parliament for 15 sitting days. And that's meant that civil society has had a much greater opportunity to have a look at these bilateral arrangements, particularly in the trade area. The reality, however, and the one that concerns me a little, is that this is quite sophisticated law, and it's all very well to say that they lie on the table at the Houses of Parliament, but the reality is that most people don't ever read them and certainly don't understand what the long-term consequences are. So I think it's one of those areas that's true of all human rights law, but it's eternal vigilance and people needing to be much better informed about what their political leaders are actually doing in their name.
Would either of the non-lawyers like to add something, Andrew or Tom? Or?
I couldn't possibly.
Tom?
No, I think that was a great synopsis of what the situation is, and I think there's a lot of people are pretty confident that that the plain packaging legislation will stand. But I think it's a message for all of us, as Gillian said, you've got the 15 days when it's sitting, and for civil society to get engaged, and to get engaged is to understand the subject area and to challenge politicians and make sure that they're representing the views of society rather than any other interest they may be representing.
You must be bursting to say something, Ros.
No, I thought Gillian gave a superb answer, so I'd take my hat off.
You concur.
I concur.
You concur. Other questions, please? Oh, gosh.
Hi, I'm Penelope Marshall. I'm from the ANZOG Institute for Governance out at UC, and thank you, it's been really great. Andrew, I wanted to sort of talk to you in a roundabout way about an experience or several experiences that I've had, but to get to your final comment, 4 suggestions. One of them was I was a tutor of a course where it was open slather, in terms of students could contribute whatever they liked about supposedly the subject material. It became very far-reaching, and in the end the site was closed because it just descended into flaming between particular individuals on the site. I'm also a member of the Sociological Association as well, and every year they have a conference somewhere in Australia. And one year, about 2 years ago, one of the conference presentations was about a researcher who had actually done a lot of research on what 15-year-old girls would actually post on Facebook. And it was very, very descriptive, and this was all in the public domain, and he did his research on Facebook. And I'm certain that if these girls were aware of what was actually part of the research for his paper, they would have just died in shame because it was very lurid, it was very sexually explicit, and normally these girls were quite drunk when the photos were taken and then posted, usually by friends. But it stays there, and it's then transferred, and it becomes a legal issue for a lot of people as well. But which brings me to the experiences that I've had of these open sites, and I've looked at the conversation at times. I haven't always agreed with things, but I think it's wonderful that it's there. So my suggestion is, and it seems really old-fashioned, is that there's actions and there's consequences, and that somewhere on the conversation you have to say that the level of debate is above the navel, that we are interested in your views, in your contribution, and that there are consequences if you violate those rules. They're not, I think they have to be explicit, that you will shut those comments down, as I think those people who are thinking in the community would expect them to be shut down.
Look, thank you very much. I'm going to keep these comments really brief because you may want to take a couple more questions as well. But just two quick things. One is that on our site, do have a look. There's community standards which spell it out very explicitly what you can and what you can't do. The moment there's a little button there which says report abuse, where you click it, any reader can report it. It goes straight to one of our editors. The editor reads the piece, and if they think it does contravene our codes of conduct, we take that down. But that then unleashes another floodgate in which we're accused of the worst things of all. Censorship, blocking debate, that they will take it to their MP, they'll take it to the Prime Minister, they'll take it to their university or whatever. And that then chews down the whole team, of course, has got to get involved in those procedures of dealing with that problem. So that's the first thing. Second quick thing I want to say is, I didn't mention this earlier, but we're actually looking at launching a new bit of our site, which is very much along the agenda of CHASS. So it's going to be around humanities, social sciences, the arts, and the arts into culture, creativity, and innovation as well, by the way. But the kind of debate we're having today will be on the site as well, and I'd like to encourage you to write. And the last very quick thing I've got to say is I have a 17-year-old, and I keep telling him, watch everything you put on your Facebook site. There's a picture of him in a casino. I don't know how he got into a casino, but oh my God, when I saw that picture, that stays with him for life.
Would anybody else like to add anything to that?
Yes,
Gillian.
Can I just add something very, very quickly? After the football incident, the Swans-Collingwood match, we'd, at the Human Rights Commission, had a big community announcement to promote our program called Racism It Stops With Me, and we'd worked for many, many months with the Australian Football League on this because it was the beginning of the Indigenous National Football Week. We were very proud of it, but I was watching it with horror as these events unfolded. We had a comments part of our website for people to comment on the Racism It Stops With Me campaign. But that became a vehicle for some of the most appallingly abusive language. And what shocked me over that Saturday and Sunday was that it moved rapidly from abuse of Aborigines in the Australian community to white racism and to anti-Israel Zionist comment. So I had the problem that you had. As president of a commission devoted to human rights, could I shut something down and therefore be accused, as I have been, of not supporting freedom of speech? But I decided on Monday morning that we couldn't possibly be a vehicle for this, and we closed it down. But just a small fact to add to it, is we trawled through the comments, over 200 that were so horrible, and found that actually they came from quite a small number of people who kept repeating the same thing but coming at it from different angles and different email addresses. So there's something really very sick, but I suspect it's actually a tiny number of people, and the problem is how to balance these interests but not be a vehicle for this sort of destructive language.
Or closing down debate.
Or closing it down, yeah.
Ros.
I was going to suggest that it is an area where the etiquette of conversation is shifting. It's I find that there are certain natural correctives that happen when the conversation continues. You know, apart from the individual sicko case, like the ones that you really were referring to, Gillian, there's a corrective that happens when somebody says something outrageous, and there's a confidence in being able to say something in return, and I'm quite optimistic about that, in that there's a natural balancing that's still working its way through. The forthrightness of vocabulary that you see on the web is for an old prudy like me, gets a bit offensive. But you know, I think people get over that at some level, and I would like to see that natural corrective happening. I mean, when we first started using online forums at the ALRC, some of my young colleagues were going, oh my God, we can't let them say that. And I said, just sit back, chill, you know, and you get the corrective happening with other people coming in. And I think that's really good, because it's about refining a conversation for other people, saying, look, you're out of line, you know, you're a nutter, you know, or whatever it is. And I quite like that forthrightness in language, so long as it is corrected. And the trouble is, as Andrew, you were saying, as soon as you start to intervene, you really distort that dynamic. And that can be a problem. So I think it is an evolving conversation. The codes of etiquette that are being articulated are still evolving in there. But I think there is a certain natural corrective factor that happens for the people that get online and engage in that kind of conversation.
Look, I've been told we have to conclude there. But in a way, it's a nice place to conclude, because I think Ros is expressing some ultimate optimism, and I'd like to think that's where we're going to, frankly, and that we'll work our way through it and get to a wider conversation, which is for the good of all at the end. Look, thanks very much, Tom. Thanks, Ros. Thanks, Gillian, and thanks, Andrew.
Thank you.
Terrific.
Thank you.